So welcome everyone, and thank you for joining us today, both online and for those of you here in person. We acknowledge that the land that we meet on today is the traditional land of the Kaurna people, and we respect their spiritual relationship with their country. We also acknowledge the Kaurna people as the custodians of the Adelaide region. Their cultural and heritage beliefs are still as important to the living Kaurna people today. We also pay our respects to the cultural authority of the Aboriginal people visiting from other areas of Australia. DW Fox Tucker Lawyers has an association with the Aged Care Industry Association, and we have a large number of professional advisors with expertise relevantly to today's talk in commercial and tax advisory work, dispute resolution, wills and estates, and in-estate litigation. My name is Alicia Wood, and I practice in our team's commercial litigation and dispute resolution team. I have a particular interest in contentious trust and litigation and wills and estate litigation, which involves me working closely with our wills and estate team. I'm from Adelaide, and I've worked over the last 20 or so years in a number of law firms here, and I've also worked for 5 years in the area of contentious trust litigation and dispute resolution in the Channel Islands, which is in the English Channel. Welcome. You haven't missed anything yet. So today's presentation is the ABCs of debt recovery in the aged care sector. And it was proposed following discussions regarding the Aged Care Task Force report released in 2023. As many of you will be aware, that report, relevantly to today's presentation, highlights the need for an overhaul of the sector's structure to permit financial viability. Some of the recommendations in the report include the phasing out of RADs, the refundable accommodation deposits, and this will mean that all incoming residents will eventually pay using a rental model, making outcomes for residents more consistent and fees easier for older people to understand. As the report states, a rental model will also give providers greater certainty around cash flow and remove insolvency risks caused by having large liabilities that could fall due at any time. This shift in financial model necessitates, I believe, a shift in focus to efficient record keeping and sound debt recovery processes that should be implemented now, ready for that shift in structure. Now, this is just a sort of a summary of the overview. I've selected some focus areas that I think arise in debt recovery for the aged care industry. Even just meeting one of you today, I picked up some issues. So if there are industry-specific issues that you would like some guidance on, while I can't give advice today that's very specific, by all means, email me or call me after the session, and I'll most certainly endeavour to assist you or point you in the right direction. For those people online, please feel free to email or message in the chat room. I'll certainly get back to you. So just going through the overview, I'll address debt prevention and mitigation strategies. So that is, prevention is better than cure. So make sure you have your records correct. We'll go through resident agreements and the key documents that you've got to obtain at the outset if possible, and even revisit and get them because they're essential to debt recovery and enforcement. So then I'll talk about debt recovery procedure. I'll also touch on how you might pursue attorneys who might be misusing the funds, and that's a fairly strong wording, but misusing the funds if they're not paying the residents' liability, it really is. So as harsh as that sounds, that's mean, or not paying fees, as I say, to the service provider. And then how you might pursue debts from a deceased estate, in which case you might be dealing with the executor. Welcome. So really gross sandwiches, anyone distract me, it's totally high water. Take a seat wherever you like.
Sorry, Alicia, can I ask, do you mind if I ask a question?
Sure.
Touched on before about the potential structural change about the RADs going away. Did you mention, I'm sorry to yes, did you mention about when that's proposed?
Well, the recommendation was quite a bit. I do actually have that right here. The question for is the Royal Commission recommended cases the phasing out of the refundable accommodation deposits from July 2025. So fairly soon, but this task force report suggests that that's too aggressive and would need to be implemented in a much slower fashion. Their recommendation is in these terms. Following the independent review in 2030, transition the sector by 2035 to no longer accept accommodation deposits. So it would be a gradual step to phase out those. That's what it's scheduled.
What did you say about 2025? Just for start.
We're talking about when, so just to recap, the Royal Commission recommended that the phasing out of that from July 2025, but the task force report suggests that that's too aggressive and not feasible. That would happen perhaps within 10 years' time, not 1 year's time.
Okay.
All right. So now, just sitting with that first topic, debt prevention and mitigation strategies, as I might just leave that topic, that slide up there for those who are just around. So the first thing I'll talk about though is key contract terms and documents. Now I appreciate there are a number of documents that under legislation you're required to enter into, but I'll loosely refer to the resident agreement for today's purposes, so that I can give you some guidance on the things that from a debt recovery perspective are good to ensure you've included. So there are some essential terms and considerations under the legislation that you need to include, but you ought to ensure first and foremost that all of the details are properly completed and crucially that it is properly executed by a person who has capacity. I appreciate that's a significant factor for your industry, making an assessment, and it's not something that anyone, a layperson, can necessarily do. Perhaps in your industry you're better placed to be able to do so. In my industry, when you're preparing a document for someone, it is an essential step that we take to ask a number of questions to ascertain for ourselves the person has capacity, but we would get a medical practitioner to ask those questions to document that they formed that view. So when you're on admission from a resident, you'll be, I imagine, in your day-to-day practice making that assessment about whether they have capacity to enter into the resident agreement themselves. It's appropriate for you to ask questions about whether they have testamentary documents executed and in their possession, and those are, as you're well aware, a power of attorney, a will, and also what used to be called a medical power of attorney, that's now a so that's the financial one. The guardianship. It's it will come to me in a moment, but it's everything about the medical care, and that's it's guard. Yeah, for guardianship. It's got a. But it will come to me in a moment. So if someone comes in and they're entering into this resident agreement, as you're probably aware, a next of kin cannot enter into a resident agreement for the resident unless they have a properly executed power of attorney. Being next of kin doesn't permit them to contractually enter into that document. So if the proposed resident does have capacity and doesn't have a power of attorney, it should be your strong recommendation that they enter into one. It doesn't have to be effective immediately. If they're nervous about signing away their financial control to someone, as you have probably seen in looking at these documents, it can be expressed to be effective immediately or expressed to be effective upon my lose capacity. But it's essential with an older person that they have this in place so that for your debt recovery in due course, it really is. So it's entirely appropriate for you as the service provider to be requesting and keeping a copy of the power of attorney with the resident agreement. So it ought to be executed fully by the resident themselves or someone who holds a power of attorney. And such as I haven't made that clear already, if someone's signing it pursuant to a power of attorney, you need to check for yourselves that they do have an effective ability to do so now, that it's effective immediately. Similarly, from a debt recovery perspective, when you're entering into a resident agreement, it's appropriate that you ask if they have a will and that you take a copy of it or at least cite it, because that will be essential for you down the track if you're pursuing, as I'll get to later, pursuing the estate. It's just a key step for you to have identified who the executor is, because that's who you'll need to deal with. If there are any guardianship or administration orders that have been obtained, you ought to be given a copy of those, and it is entirely appropriate for you to ask for one. It's also entirely appropriate for you to ask, and if you don't have one of these forms, I'm more than happy to assist you in preparing a precedent, is an asset declaration. So the resident would complete an asset declaration so that you know, and that will be an essential tool later for you in identifying or registering security against assets, and also identifying steps you can take to enforce a debt. So it's appropriate that you request that they complete an asset declaration. Armed with that asset declaration, you ought to conduct searches for property titles to see what properties are in their names, and PPSR searches if they have other sorts of assets. So getting to the resident agreement. As I was saying, it's essential that it's properly executed and signed. You ought to, I'm sure all of these things are already in your precedents, but just going through them one by one, that you ought to include an estimate of fees, including the maximum payable if there's no assessment at the relevant time, the interest payable and the manner and provisions for ensuring that you can recover them. That enforcement costs will be recoverable by you as a service if you're forced to pursue them for fees that they haven't paid. Default provisions, which say that after X number of days you're permitted to issue a notice, so that's a good thing. They're standard clauses that we input. Security provisions, including a deed of charge and the power in the contractual terms to permit you to lodge a caveat over their any real property that they hold. Caveats are a really tricky area, and you need to ensure that you have created a caveatable interest that permits you to register a caveat, and that's something you should get legal advice on. You should also consider getting a third-party guarantee, and that would usually be provided by the next of kin. And in circumstances where the resident is partially supported in respect of government assessed levels of contribution, hopefully you would never have to call on a next of kin guarantee, but it's a protection mechanism that will permit you to exercise some sort of degree of enforcement against them that might make them move. The enforceability of a third-party guarantee is a topic in itself I could talk about all day, but for today's purposes, a guarantee should be clearly set out. It can't be hidden in the terms of the agreement, which is again why it's something that you should get properly legally drafted. And even just once, a precedent that a lawyer has said, yep, this is good for you, and you can just roll it out again. The obligations of the guarantor should be clearly stated. There should be a disclaimer which sets out that they either confirm, this is the guarantor, the next of kin, that they have received independent legal advice and that they've had an opportunity to do so. If you're later enforcing a guarantee, these steps will ensure that you can meet allegations by the individual who provided a guarantee that they didn't understand they were signing a guarantee, or that they were somehow unduly influenced, which is something that could easily be manufactured. I was in a stressful situation, mum was really unwell, I was desperate to get a position, I signed it not knowing what it was, and that leads to in disputes. All of your records that you've created are crucial if you came to me and I was trying to enforce a guarantee. So keep a file, and today it's easier to keep files because you put it in an email or scan it in, so we're not talking about boxes of paper, but keep a record of when you sent this guarantee to Mr. X that shows that he had that guarantee for 2 weeks before he signed it, which is more than sufficient opportunity. So when he says, oh, it was put in front of me on the day I signed the agreement and I didn't get a chance to consider it, you can go, well, no, here's a copy of me sending it to you 2 weeks before. These sound like little things now, but they are protection mechanisms that will save you if you enter into something like a third-party guarantee that you're later trying to enforce. Record keeping is crucial in establishing and winning in debt enforcement. And it's a tricky area, guarantees, and it is something that should be drafted by a lawyer that you can, even in a precedent sense, that you can then roll out. I'm sure you all include in your agreements and try to require and set up automatic direct debits, but as I've already discussed with someone today, that a direct debit could be cancelled, but that is again another protection mechanism that you ought to set up at the outset and again come back to and ensure that it's in place so that you're not sending an invoice and hoping they'll pay. We require a direct debit arrangement. I need to see evidence of it. And this is, it's these are difficult conversations, possibly with an elderly person, but that's the attorney or the next of kin. This is what we require. This is what we require. And it's a friendly discussion, but it's essential. And you can be sure that in other industries and other services that we all have, like my lawnmower and my cleaner and my gym, they don't send me an invoice and expect me to and wait for me to pay. They insist on this arrangement, and you ought to as well. Any difficulties? Another protective measure is to be alive to difficulties with payments and delays in payments, and act on them early to minimise that accrual of debt, and make contact early with the families and the resident. Keep it friendly, make sure that you move on it so that you don't have this difficult situation that's much harder to confront. Consider offering discounts for the early payments of bills. I've done that, and it's you know, sometimes it's better to take a hit than get nothing. And as I've already got another note to myself to say, document communications with residents. I'll get to when you might come to a lawyer, but these are all self-help steps that you ought to be implementing and adhering to. You should have policies about what your debt collection process is. So 30 days overdue, send a friendly reminder notice, follow with a phone call. 60 days, send another reminder notice, follow with a phone call. Invite a discussion, invite a meeting, have a process so that they don't get away with the accrual and the building up of debt. And each of those steps should be recorded. You should have a file, and it's easy to maintain a file. It could be, you know, it typed into one document. On this date, I called and spoke to so-and-so. This is what happened. And then that's presented to me as a lawyer. I've got this record of you in a friendly way trying to follow that debt, and not once in there is there criticism of your services. Not once. So when we get to court and they say all these reasons why they couldn't pay, it's like, well, that was never raised before. You sure it's only because you don't want to pay? And you see that sort of thing happening. So documenting your efforts to secure payment is crucial to protecting yourself and your centre. One of the things that came up in a discussion earlier that I might just touch on, one thing that is an issue is the refusal, or this long-standing issue where you've got a resident agreement that isn't signed. A contractual, I'll just deal with that. In a contractual principle that you may not appreciate is that you can accept a contract by conduct. So even if they've refused to sign, send it back to them. Send it to them and their family. Here's our resident agreement. As you know, it's in place. We accept your, you've moved in, you've been paying. We take your conduct as acceptance of our contract. So you've documented it and you've made it very clear in writing that that agreement is in place, and that's the agreement that you're invoicing them pursuant to. And that does overcome this issue about, well, we don't have an agreement, we didn't sign it, because there is an agreement and it binds them. So I've gone through contract terms and documents and the essential terms and considerations of your resident agreements. Worrying, we have a wills and estates team here. These are aged care directives. That's the word I was trying to think of before. They used to be called medical powers of attorney, but now aged care directives are the document, and they're available online, and they'll be where you might fill in wishes about your care in the future. I'm sure all of you have seen them. So this is the suite of
the advanced care directive.
Advanced care directive. That's a true. I personally don't do them, but I'm familiar with them. That's a typo. So advanced care directives, a will and an enduring power of attorney are a package of documents that I will loosely refer to as your testamentary documents that every person ought to have at any age, really. Heaven forbid anything happen to any of us, but particularly someone facing older age, in case there are testamentary capacity issues that develop, which will affect your ability to, coming back to today's topic, enforce arrears if you don't know who you're dealing with and you don't have an attorney appointed. You're then left to really the option. The family themselves are faced with a need to go to somewhere like SACAT and get an administration order if they don't have the protection of a financial enduring power of attorney at the time. They cannot deal with the deceased, the resident's estate or their assets. They cannot deal with the resident's assets or even access and pay money from their bank account statement unless they're a properly appointed attorney or they have an administration order. And so you're in a difficult position then in terms of securing payment until such time as they pass and an executor is properly appointed. So that attorney is crucial for you in terms of securing payment. So I was going to say, these documents are available online. It's as a lawyer, it's a little bit frightening that they are available in a do-it-yourself sort of kit, because they are so crucial and they can be entered very easily. So it's worrying, and even now I've got you know, an unfortunate and difficult manner in which a lady who was gradually losing capacity has entered about, you know, signed about 6 wills, and unravelling that situation now and identifying when she lost capacity and which was truly her will is a really challenging thing. So it's essential that these steps are taken with care, with the family involved, and done at an early stage before someone does lose capacity. So I'll go now to debt recovery procedure. Like I've discussed already, the need and my recommendation that you do have, if you don't already, a clear internal policy that you and your staff roll out in an administrative way about, and there are electronic systems that can assist you with this process. You can set up precedents, so they're very straightforward to send these sort of notices and make calls and keep it friendly. You might, if you are nervous about a resident's account that is in arrears, you may take those early steps to register a caveat on their asset. I mean, precautionary, you ought to do it when they move into the centre, because these sort of securities have priority, and getting it on there earlier rather than later is really the best course. And I mean, that may create some strain with the resident or their family if they're trying to borrow against the asset, for instance, or who knows what they might be doing. But that you can negotiate that with them. It just, if it's part of your terms, then you just do it, and you're open to lifting it and putting it back on. If they want to sell the asset and buy a new one, it's something that you can negotiate with them. But my advice would be that you put it on straight away when they enter into the residence. If you so if you haven't done it at the outset, then when you identify there's a debt building up, you ought to take steps immediately to register caveats over any property that's held. If you get to the point where you are if you've sent your 2 notices and you've given them reasonable opportunity to contact you and enter into a suitable payment arrangement or satisfy you that they can do so, then you need to send a more firm demand letter. A demand letter can, if it's from you, it should go on your formal letterhead. It mustn't be an email. It should look more formal. You should set out in clear and certain terms the agreement that you're relying on, the amount that you are claiming, how long it's been overdue, that interest could be charged. You should state that you, if they fail to contact you and enter into some sort of a payment arrangement, that they risk the debt being referred to a debt recovery agency or to a lawyer. You should mention that the resident may be liable for legal costs. And that's included in your resident agreement. You must certainly invite discussion, invite them to come in and call them after. You should state that the resident can be asked to leave the service, which I'm sure all of you know could occur under the Aged Care Act if they do not pay within 42 days. I appreciate that is actually in practice a very difficult thing to implement, because you cannot threaten them or require that they leave unless there's suitable and affordable alternative accommodation available. So these security of tenure provisions in the Act really do pretty much make it impossible for you to require them to leave. I appreciate that, but you can still say that the failure to pay may result in them being asked to leave, and you can still be moving those processes in forward. If your letter of demand doesn't result in payment, then a next step will be to go to a lawyer and have them send a final notice if the debt is disputed. Under our court rules, the Uniform Civil Rules, we have a requirement to give what we call either final notice or a pre-action notice. A pre-action notice applies where there is a dispute around the debt that might have been raised by someone, perhaps around the level of care or the particular services that were charged. But assuming that this debt is for services that no one disputes, they just simply haven't been paid, it's simply a final notice. That's issued, and that requires payment within 21 days. And it's a mechanism that's been brought in the new rules in 2020 to encourage parties to have informal discussions before issuing court proceedings, with it, in the view to avoiding the cost of court proceedings. If it's a disputed matter, or you can see that there might be an issue raised, however spurious, then we use something called a pre-action notice, and that requires the other side under the court rules to provide a pre-action response, and it requires you to convene an informal mediation. It's called a pre-action meeting. And there are cost consequences for parties to litigation if they fail to go through those steps, provide a pre-action response, attend and genuinely try and resolve the matter at a pre-action meeting. If you're, in terms of the jurisdiction in which you might end up issuing proceedings, if the claim is under 100,000, you'd be in the states courts, in the magistrates court. For claims over 100,000, you'd be in the district or courts. If the person is putting their head in the sand, the family aren't dealing with it, and they do nothing in terms of the court proceedings, don't file a defence within 28 days, then you're entitled to enter what's called default judgment. Similarly, if they file a spurious defence that has no basis, you might be entitled to enter what we call summary judgment, and it can be wound up fairly quickly. You might not be caught up in long-winded proceedings, which are costly. I imagine that a lot of the debts you might have are fairly straightforward, and the debt recovery will be relatively efficient to action. And then what you've secured for yourself is a judgment which is useful for registering against assets, and it gives you priority in terms of any property that's realised, whether by the attorney or actions that you might take against the resident during their lifetime or against the estate when the person passes. Keep in mind that there are limitations that arise. You can't sit on a debt for more than 6 years. From the date that it becomes due under our statute of limitations, you do have a 6-year period in which to take steps. You can't come to me with a 10-year-old debt and hope that I can help you. It's going to be very problematic. I thought I might touch on, has anyone got any questions at the moment around that area?
Yeah. When it comes to making a decision about whether you're seeking file letters or pre-action notice, if you know that the person you're trying to recover from has just been difficult, but you've got solid ground, debt has been agreed to and incurred, are you obliged to do a pre-action notice if they, even if they come back and say, I don't want to pay this, I don't think I've got the right service, or whatever their reasoning is, even though you know that that's actually completely outside of the contract and it's really a spurious argument?
Yes.
Can you just simply proceed with the final notice?
Yes, you can proceed with the final notice in those circumstances where you don't believe there is a genuine dispute about the debt. You wouldn't have to go through that meeting stage. Particularly, and that's music to my ears if you have an admission. Another example of keeping good records. So I know I owe this, but I'm not prepared to pay. Sort of email. That's gold.
Well, thank you for the service many times and re-engaged, and now all of a sudden they've got issues that
we often see, and it's not specific to your industry. People suddenly get issues with service when they chase for payment.
Thank you. It just means that you don't have to go down that path.
But debt recovery is a portion of my practice, and 90% of matters, when someone gets a letter on a lawyer's letterhead or something with a court seal, they pay. They ring and they enter into a payment arrangement. They're worried. They don't want to be bankrupted. They don't want their assets at risk, and they know you're serious when you take that step. Sure. And you've sent them a friendly letter before saying, we regret to say this will result in us taking steps to refer it to an external a lawyer or debt recovery agency.
And sorry, a supplementary question. In that letter, is it useful to detail the steps you've taken to try and communicate?
Yes, most certainly.
Okay, thank you. Cheers.
It shows that you're trying to
Yeah.
resolve it
Thank you.
and being reasonable.
Is there a provision in case here that we cannot recover the caveat cost from residents?
Cannot recover the
The caveat,
caveat.
yeah. If we are placing a caveat on the property, there is a cost associated with that. So we cannot recover it from the resident. Like service provider has to bear it, or we can
No.
recover it.
So that's something I was saying at the start. So, again, not specific to your industry. When you enter a contract for services, it should be a standard clause that says if you default in and we have to take steps to enforce our debt, you will be liable on an indemnity basis for the costs of recovery.
I'll just check a few questions about cost of caveat.
Yeah.
But cost of placing the caveat is quite minor.
Yeah, that's a registration.
Yeah, it's like-
with the Land Titles Office.
Still, if you go through a lawyer, it's still $600-700 or something like that.
Yeah.
Yeah,
I think it's not okay.
yeah.
You're going to the wrong lawyer, I think she So we have a team of, in the debt recovery team, we have a team of people, including paralegals, who do steps. So I don't have to physically do those little things that ought to be fairly run of the mill, and they can do them fairly quickly. That shouldn't cost you $700. I haven't personally lodged a caveat for a while, but someone in my team better tell me that the LTO fee is wouldn't be more than $200, but I have to check. It used to be 91, but that was a long time ago. All right. So where did we get to? So you might have a situation where you are dealing with an attorney, by which I mean a financial attorney. So we're talking about enduring powers of attorney, which will either provide for the attorney to have control of the resident's financial affairs, either immediately upon execution of the attorney power of attorney or upon the losing capacity. So it may be that your first point of call when you're dealing with how much have they paid, are they going to pay, is that attorney, who are they? It's essential that you know who they are and that you have a working relationship with them. If you suspect that if they are not paying, they're refusing to pay, or you suspect that they're applying the funds in a way that they ought not to, they may be next of kin, they may be someone else. There are steps you can take to apply to SACAT for orders removing that attorney and replacing them with someone independent, for instance, an accountant or the public advocates. There are steps that can be taken. It's a step that could be taken for by nearest relatives, by a social worker, by a close friend, or even by you as a service provider. And of course, there are cost consequences in doing so. So it's a difficult step to take, but if the debt involved is significant, it's a quick and easy way to remedy that situation instead of writing that debt off. There is also scope for compensatory orders to be made against an attorney if you can establish that they are misappropriating funds or not paying your fees, and your fees are proper liabilities of the resident in their lifetime, and then subsequently proper liabilities of the estate, which ought to be paid out first in time. And I've just got a note to myself here, the justification for making that application would be that the attorney is not making decisions in the best interests of the resident, and as a consequence putting the resident's accommodation. To avoid these, I'm going to get repetitive here, but to avoid these kind of debt situations, it's record keeping and getting in those key documents which are crucial and essential to assisting you in debt recovery and identifying the steps that are available to you. So when you're dealing with executors, so an issue might arise where a resident has died, leaving behind unpaid service fees, and it may be unclear who you are to pursue or how you are to pursue that debt. As you probably realise, the estate itself is not a legal entity in itself that is capable of being sued. The appropriate person that you sue is the executor. And whilst they may be appointed by the terms of a will, their appointment is actually not formalised until a grant of probate is obtained. if probate's not necessary and you need to issue proceedings, that issue can be resolved by the leave of the court. But it's usually more commonplace that you're waiting for probate to occur before you can take an active step. So the first issue is identifying who that executor is. If you've taken the steps I recommended at the start, you might have a copy of the will, or at least you've noted on their file that you cited the will and so is the executor. You might know who the family solicitor is and have a person to contact. These are, if you have a copy of the power of attorney, you can look at who witnessed it and what lawyer prepared it, because those testamentary documents are often prepared at the same time. So the witness provision might alert you to who prepared it, and the person who's going to refer might similarly, and is often the executor under the will, and that might give you the avenue to who the executor is. Care should always be taken to locate and identify the last will of the deceased, and that's something that's really an obligation on the family, but there are, it might be something that you're involved in. So if you have a copy of their last will, that will no doubt be of assistance in terms of any debt recovery that you're required to undertake.
One question on the executor. So in the period before any probate is granted, what are I going to do in terms of the bank accounts for the resident, or making changes or making payments and so forth?
What are you or they?
The executor. So the executor, probate has not yet been granted. That could take some time. Are they allowed to make these payments?
I might have to come back to you on that. It's really a probate specific question that I have to get a colleague to answer you on. Limited steps. They need to get probate first, as I understand it, before they can, if they don't have power of attorney.
And probably, it's a 6 month process, not
It's around 6 months usually, yes. So not all estates require a grant of probate. For instance, if the deceased did not own any real property, or if they owned property in joint names, in which case the property will pass by rights of survivorship to the surviving owner, and probate will be required. Similarly, if there are accounts in a husband and wife's joint name and one of them passes, then there might not be any need for probate to be obtained. If you're endeavouring to identify who the executor is, you can conduct searches of probate registers each online in each state and territory for a fairly nominal fee yourselves. From this search, you'll be able to see the date, and monitor and see the date on which probate's obtained, and it will tell you the lawyers that are appointed in respect of the grant of probate, and then you can make contact with the executors or the solicitors acting for the executors, and ensure that they're aware of the liability if the executors haven't brought it to their attention already. Probate is obtained, or you need to obtain probate in the state or territory in which the assets are held. So you might have a resident here in South Australia and their family will live here, but actually they only own property in Queensland. So if you're diligently searching the Supreme Court here for a probate search, and it won't show up because they might only get probate granted in the Queensland Supreme Court. That's just a little thing to be aware of.
Quick question. What happens if they've got property in 2 states?
They register it in a primary place. The grant of probate, for instance, will be obtained in Queensland, and then it has to be registered here so as to deal with assets in South Australia. So it gets registered in multiple jurisdictions potentially. Okay. So you'll eventually see it, but you might, if they only have assets in one jurisdiction, then that would be the asset of the jurisdiction. This is an anomaly, and it's you'd think it would be where they're resident, but it's to effect a transfer of property in that particular jurisdiction. So that's where the grant must be obtained.
I'm just seeing if my lady, she's got a property in Victoria and a property here.
Right.
Get a bit tricky.
So you have to get just get the grant here, and then often the grant will happen in the place that's most convenient to the executor and where they've got a lawyer located. In terms of enforcing debts against deceased estates and executors' obligations, I would just mention that there is the new Succession Act that was passed last year, 28th of September 2023, but its commencement is yet to be proclaimed. It encompasses succession law in South Australia by repealing the Administration and Probate Act of 1919, the Inheritance Family Provision Act of 1972, and the Wills Act of 1936, and amends various other acts. It consolidates and amends the law relating to wills, probate administration, and the administration of deceased estates, intestacy and family provision, and it codifies rules regarding the payment of the deceased estates, and these were previously governed by fairly complicated common law rules. You'll probably be aware that there are an executor has certain obligations and duties, and they are primarily to collect in and or call in the deceased person's estate and to administer it in accordance with the terms of the will or at law. If the deceased died intestate without a will, the estate vests in the public trustee until such time as a grant of administration has been ordered, if required. Properly appointed administrator has power to sell assets and is obliged to pay the liabilities of the estate, including levy fees. If the estate is solvent, this may result in a full recovery for resident fees that may be due. If the estate is insolvent, where the liabilities exceed the available assets, and aged care providers' recovery prospects will be improved by security held over assets, including caveats that we've talked about today, or judgments that you've proactively taken steps to secure and register against the assets of the deceased. Creditors can apply for letters of administration where steps are not being taken properly to administer an estate. If you have any concerns as to whether an executor is acting appropriately, application can be made to court for compensation against the executor. And even suggestion that such orders might be sought in a letter might be sufficient to prompt an executor to take appropriate steps if they realise you're serious about. Something I did come across in my learning and it's something I'm sure all of you know a little bit more about, but when you have these RADs, these refundable accommodation deposits, there's an obligation on you to refund them fairly promptly after someone passes, and that can be problematic if you don't know who should provide them to, and you've got interest accruing on them. So one of the things I did come across is that you can explore entering into a deed of release and indemnity with the family members. This might only be appropriate where you've got a fairly small estate or relatively simple estate and the family are on board, but the effect of it would be to avoid those delays and uncertainties, and would document the family's agreement as to who the RAD deposit can be paid to, so that it can be effected prior to and notwithstanding delays with probate. It might be something that you'd be interested in exploring, so I just thought I'd note that.
Is that an agreement that you would try to enter into prior to that competition?
Can I just comment on that? The RADs are a great protection for any fees that are paid, right?
Yes.
And some side you mentioned, I think, are very logical. And
Is there more steps that you take in circumstances where you're doing contributions or rent arrangement, which I understand we're moving towards?
Yeah, they're often that you either have a combo rent.
Yes.
And so you can encourage them to pay it for $50,000.
Yeah.
And that gives you comfort that fees that do accrue aren't paid. You have some protection.
Yes. Yes. So how do you feel about the phasing of them out? Not
So
sure about it.
in 2025 and then
10 years, it sounds like
it's
it's not going to happen.
Yes, from
Yeah.
that.
Well, hopefully some of these steps are still useful for you in terms of the co-contributions that you're supposed to pursue. Sounds great. Is there any questions I can address today, or feel free to
I have a question from one of our webinar viewers. I just asked, if a resident is vulnerable, for example, if they have dementia, and the power of attorney is unresponsive, would you advocate seeking to appoint an administrator in the first instance rather than seeking to issue a statement of claim? They're thinking about appropriate conduct in the meaning of debt collection guidelines for basic and major.
Yeah. Yes. I mean, you have to deal with each case on its merits and deal with, that's unfortunate if the attorney is non-responsive. Have to consider what's happening there and if suitable steps are being taken to try to contact them. But yes, perhaps best and there's other considerations like how elderly the person is and whether it's going to resolve. What you want them to do is ensure that their accommodation remains secure, but secure payment. So removing an attorney who's not fulfilling their functions is probably the preferable course, and appointing the public advocate to ensure that funds are being appropriated from the incapacitated person's accounts to ensure that their accommodation is secure, rather than issuing us court proceedings which secures a lump sum now and you don't have certainty around going forward. So most certainly my view would be the safe hack course. Yeah.
Do you have a general rule of thumb of amount that you might recommend to providers? Go, this certain amount, yes, it's definitely worth getting legal guidance, below a certain amount.
It's an age-old question, isn't it? When is debt bad debt? I think it's again, it's specific to the particular individual. So if you, none of us know how long anyone's going to live, but I think that would be a relevant consideration. Similarly, and as I didn't cover it, in any debt recovery, so thank you for this question. In any debt recovery, whether in the aged care industry or anywhere, an initial inquiries by us as a legal team would be, what is the capacity to pay? What is the prospects of recovery? So if you come to me with a potential debt of 50,000, I'm looking at conducting title searches and electoral roll searches and trying to find out what assets that person has if you don't already know from your inquiries when they moved into the facility. So that would be a key and relevant consideration to whether you take enforcement steps at 50,000 or whether you let it accrue anymore. If you've got the security of a caveat over their property that's worth $2 million and there's no other encumbrances on that property, then you may feel fairly happy to sit and wait. Yeah, so there isn't really a rule. Yeah, but it's specific to your facility, how much debt you can bear.
I guess on the other side of it is also, is there an amount for us to consider on a resident's passing? And let's say we don't have any equity of RAD, you know, and they owe us, one resident owes us 3,000 and one owes us 30,000 and one owes us. At what point do you go, okay, well, that's the kind of amount that
you don't know.
Yeah.
But do you take active steps to get in contact with the executors and
yes, so
they're aware of the liability?
Yes, and then at some point we realise that
$3,000 doesn't warrant legal fees, in my humble opinion. But claims that if you're not to get it, anything under 12,000 is a minor civil jurisdiction in the magistrate's court, and you can represent yourself, and it really is a people's court. It's there, the magistrates are there to assist you, and you should feel comfortable going in there and advancing your claim, particularly if it's not contentious. Our legal team will assist you in the process if you don't feel comfortable, but it's very much encouraged that claims under 12,000 people represent themselves and try and pursue those debts without incurring significant costs. But yeah, sadly, court proceedings cost money, and whether you're pursuing 100,000 or 100 million, there are steps you have to go through. Hopefully, as I said before, these sort of liabilities are less contentious, limited grounds for non-payment, so it should be relatively straightforward if you want to enforce them. And then if you're dealing with an executor, it's awaiting and just making sure that you've taken those preventative steps to ensure that you might have security to protect your recovery rate.